Court will now call case number 124529 in the matter of the marriage of Lisa Michelle Shafer, as Webster, now known as Webster, sorry, versus John Francis Shafer.
May it please the court, Joseph Dwoskin appears with Ronald W. Nelson on behalf of John Shafer, petitioner, appellee. I would like to reserve 2 minutes for rebuttal.
2 minutes is granted.
The law does not reward idleness. In this case, a judgment was entered. Nothing was done for over 12 years. Nothing. The district court in this case found that nothing was done. Idleness is not rewarded. 60-2403 provides that a judgment becomes dormant 5 years after the judgment is entered and expires 2 years later. A judgment is a final determination of the party's rights in an action. This court has said numerous times that the term final judgment is self-defining. It refers to an order that definitely decides and terminates rights or liabilities in an action. This court has also previously said that in a divorce, the decree is a judgment, or at least the final determination of the rights of the parties is a judgment that is subject to the dormancy statute. In this case, a judgment was made. Now, the Court of Appeals said that that judgment was not a final judgment, and the Court of Appeals in this case said that it was not a final judgment because what was being ordered by the district court could not be determined. But that's simply not the case. In Judge Slater's decision, he specifically indicated that 50% of the marital portion of the military retirement accounts would be set aside to Lisa Shafer. Lisa Shafer did nothing after that until a motion to clarify was filed 15 years later that led to the determination by the district court in this case that nothing had been done, that nothing had been preserved, that there was nothing to protect the judgment done. And that, again, time does not simply stand still and delay is not rewarded. In the Kelter case talked about final judgment again. In that case, there was a pending motion. In other cases that this court has looked at and determined that a final judgment, or the Court of Appeals for that matter, has determined there was an issue outstanding. There was no issue outstanding in this case. There was no domestic relations order filed or requested until long after 5-7 years after the divorce decree was entered. And the district court judge specifically found nothing was done, nothing was attempted to be done during that time.
I don't think that's there's really no dispute and nothing happened.
That's right.
So I think we got that part. I'm having trouble with the Court of Appeals decision that when it says that words to the effect that I had it right in front of me here, that the precise length of the party's marriage was not readily discernible from either the decree or the division of assets. And when I look at it, I figure out that they were married 15 years, 9 months, 15 days, or 189.5 months. And I know the Court of Appeals said this was not a final judgment because of that. If we can do that, if we resolve that, does that resolve the issue as to whether this is a final judgment?
Yes, and in fact, I will refer to the appellant's brief in regard to that. The appellant stated in her nature of case, the parties were divorced in 2006. The term of the marriage was for 190 months, going to what you just said, Justice Biles. The wife was granted 50% of her husband's retirement benefits from the military as of the date of the divorce. Husband retired 15 years after the divorce. Wife filed to receive her benefits.
So
Again, nothing was done.
So if we find the Court of Appeals erred in categorizing this as not being a final judgment, I think that means the dormancy statute applies. Explain to me why since you've heard all the questions and everything, explain to me why subsection C of the dormancy statute doesn't mean what this court says it means in Bank 4 Wichita.
The dormancy statute talks about 5 years from the judgment. So the judgment was the date of the divorce. First decree that finalized everything. 5 years after that, it goes dormant. 2 years after that, it becomes expired, and the district court has the obligation under the statute but something has to be done in order to protect that, because
Well, wait a minute. Subsection C says that to prevent a judgment from becoming dormant does not run during any period in which the enforcement of the judgment by legal process is stayed or prohibited. And this woman can't collect that judgment until he retires. And so why isn't that a period of time when enforcement of the judgment by legal process is stayed or prohibited?
in terms of retirement accounts generally. But specifically with regard to military retirement accounts, the enforcement can be done. It's the collection that doesn't occur until later.
What is,
Bank 4 Wichita.
what actually happens with inside the accounts?
What actually happens in military division is, first of all, the divorce decree can be submitted if it contains all of the elements required by.
Let's just say it
the
does.
FAS.
What does the plan administrator do?
Then the plan administrator sends a letter acknowledging that it has been received and that it complies with the requirements.
Do they segregate accounts and create?
In the military, they don't. They simply send a letter saying your military division order is approved and ready for division whenever retirement occurs.
So the spouse that is been awarded a portion of the benefits doesn't actually have any sort of possessory interest until the retirement happens.
There is a possessory interest when the military division order is approved. Because that, well, and another thing that goes along with that is.
Could that be appropriately described as a collection on the judgment?
The sending in and the approval of the military division.
I'm just
order.
trying to figure out
Right.
whether she got anything. Did she get, I mean, that's what collection means. It's like, give me what I'm owed.
Right.
And just in very pragmatic terms, does that happen in this particular plan, and obviously you heard the questions in the prior case, I'm trying to figure out whether or not the spouse who's been given this judgment is actually getting anything.
With the military, there are no separation of accounts because it's one account.
It's really just a notice provision.
It's a note, but she is entitled to receive whatever he is entitled to get because of that approval of the military division order. But if that isn't sent into the military and approved by the military in appropriate form, then another spouse can come in and get ahead in line and take whatever there might be from the first spouse if the first spouse didn't protect her right or interest, which again was done in this case.
The condition precedent to enforcement of a judgment?
If Lisa Shafer sends in and obtains an approved military division order ahead of retirement, then a subsequent spouse cannot receive her portion. Lisa Shafer would receive her 50% of military retirement. But if that is not approved by DFAS, DFAS doesn't know that anybody exists.
But still, everything's going to circle back to the dormancy statute.
Right.
I mean, we're not talking about the military saying, oh, well, we don't take any divorce decree that's more than 7 years old or whatever. They don't care how long it took. The issue is whether Kansas statute applies. So getting back to my Bank for Wichita question, can you explain to me why it's wrong in this context?
Because you have a judgment. And the right to receive the property interest doesn't wait until the retirement begins. The property interest is at the time of the decree. It's just that the amount hasn't been determined yet.
Have the right to do anything at all with that property interest. For example, determine how it's invested, determine whether it's divided into two accounts, one that is certain expenses.
With federal military, no, because that is ever changing, depending
he?
on what Congress says.
Does the husband? Doesn't have the right to do anything at all with it.
Can she call and find out how much is in there right now?
Shifting amount, depending on the rank, number. Factors. So.
But like with when I was working for the feds, I could, there's not an account, you can't even. They don't send you a thing telling you the money that's been invested.
Because it's the federal government and they don't invest it. It's just part of the budget and part of the full faith and part of the United States. Military retirement is very similar to federal retirement.
What if you have a question about, am I, when am I going to be vested? There's someone to call, right?
There is no vesting.
Oh, you just work a year and you're in.
And it depends and shifts. With the military, FAS will not make direct payments to a spouse till after the member has been
Do they even have to take her call?
That's what I want to know.
No.
They have to take his call?
But they, I think they would take her call if they had a file. I'm right. Unless they are notified that there is a division of the military.
Know if they do anything other than, okay, thanks for letting me know. They send the letter,
They send.
says thanks for letting
They
me know.
send the letter, and oftentimes, just as with qualified domestic relations orders, administrators, they specifically identify that something is wrong with this proposed order. And that's apparently what happened in this case, because Lisa supposedly sent the divorce decree in. They said, what is required? And what is required is specifically identified in federal law and finality is not determined by a party's conduct. Finality is not determined by a third party. It is determined by looking at the judgment. The divorce decree is a judgment. With regard to the other case, I see that I am past time, so.
It please the court. Again, I'm Bruce By. I represent Mrs. I think the court's boiled this about as much as I can possibly help you boil it.
Well, explain to me why this isn't a final judgment, because that's what the Court of Appeals said, and it doesn't make any sense to me. They say you can't calculate the time of this marriage, and you stood up during from what I remember from the transcript of the court hearing, you stood up and said, it's right, all right here, Judge. All you have to do is just pencil it in. I mean, I think you went to 190 months, and I would go to 189.5, but we know exactly, don't we know exactly how long this marriage lasted? From the divorce decree and well, from the memorandum decision from Judge Slater, and then from the divorce decree.
There isn't any doubt in my mind. I can read the decree as well as anyone else can.
Was that Judge Eisenhower that signed the decree?
I think it was Judge Eisenhower that actually signed it, but Judge
Slater did.
Judge Slater entered that. You know, it's there, but, you know, he sent the letter to DFS timely when she found out he was retiring. He didn't tell her. She just found out through the grapevine. So she immediately said, I want my share. So she sends at that point DFAS, the decree, and DFAS sends it back and says, we think it's fine, except that we need a specific number. Now, I agree that all you got to do is read the plain face of the decree, and you can come up with 189.5 or 190 months, or however you want to, somewhere in that neighborhood. I agree with that. That's true. But that's not what DFAS said.
But that really, whether the military can read this or not, doesn't matter. It seems to me the issue for us is whether the district court has the ability to give you the clarification you've asked for. Or is it precluded by the dormancy statute? Agree that that's the way we need to look at this?
I agree that's the way you have to look at it. I don't see a way around that, which is why I didn't file to modify or alter the original decree. I did what DFAS required Mrs. Shafer to do. And that was to clarify it. Okay, now, again, I thought it was perfectly clear, but if they say they need a number from the court, then I think the court, and I asked the court to specifically give me a number, and the court declined, saying, I think I'm modifying the decree. So I don't, my facts are different. But my client did what she thought she was supposed to do. Timely fashion. She'd like to have her share.
Why isn't giving notice to the plan administrator of the decree enforcing the judgment, as that term means in 2403C?
Let me answer that with this, because I think this is where you're going, and I think this is what you really want to focus on. Correct me if I'm wrong, but let's assume that Mrs. Shafer had sent that decree to DFAS within 6 months. The entry of that decree. Let's assume that that's the case. I don't know what DFAS would have done with that. In theory, I guess, DFAS could have sent a letter back to Mrs. Shafer and said, we need clarity. We're not clear as to what this is. And once you get that, then we're fine. But it didn't happen.
And that kind of the purpose of the dormancy statute in general is just to say,
Generally,
Take
I
steps
think,
to
I think that's correct, Justice. That, look, Larimore created a huge can of worms. Domestic bar.
why is it, that's one thing I don't understand. Why is it such a can of worms? Well, why is it so hard just to put
Because
the plan administrators on notice?
prior to Larimore, there was no generalized rule that dormancy applied to the division of retirement accounts. It just didn't exist in the domestic bar. Larimore basically.
I understand it creates a change but what I'm struggling with is, why is this change so awful? Why is it so? It doesn't, I don't understand why it imposes this huge burden to say, well, look, if you don't want this judgment to go dormant, you've got to take the steps to execute on it, which means at a very minimum, it means giving notice to the plan administrators.
Let me answer that in this vein. I don't know a practitioner in my neck of the woods that prior to Larimore ever advised their clients that dormancy would apply to the division of retirement account. If somebody did that, bless their heart, but I don't know of a single domestic practitioner who did that, because it never occurred to any of us that dormancy would apply to these accounts.
So you're saying that, not that, okay, I think I understand better. You're saying not that this can of worms exists in a going forward sense. You're just saying that you were caught in the middle, because by the time Larimore came out, you may have already run on your time. Am I understanding what you're saying now? Because you're kind of saying, look, if we had known, we would have done this.
Not the only one.
But am I understanding you correctly?
Or
Okay.
I've had at least 2 other clients that I had done prior divorce cases with, who following Larimore, I had the unfortunate situation of contacting them and telling them, you should be entitled to this, et cetera, and we probably better file something right now to try to protect it.
Have you made any kind of equitable tolling argument in any of these cases that's grounded in what you're just now saying?
I've made those arguments to district court. I've made those very arguments. None of those cases, in those cases, my clients declined to appeal. And I, Laramore's the problem. I don't know what the solution is. I don't. I'm not going to pretend to tell you what the.
But if you
solution-
think there's a rule that applies to you as an attorney, you're going to try to follow the rule, whether you think it makes sense or not, aren't you?
Yes, ma'am. But again, prior to Laramore, there isn't a domestic practitioner that I know in my county or Wyandotte County or Miami County who thought that dormancy applied to division of retirement accounts. I don't know of a single lawyer who advised their client pre-Laramore that that was the possibility. If they are, there are a lot better lawyers than I am, and there's certainly plenty of those out there, but I don't know of any, and I know plenty of darn good domestic practitioners. So I think I don't know how I could make this any clearer. And again, my facts are different. I think I've got nice, clean facts, and I wish I could just argue my facts again and again and again. But in reality, the problem is Laramore. That's your issue. I don't have your solution, but you clearly understand that's your issue. Any questions from the panel?
If I could, before you start, I just want to get your response to my, or maybe it's a right field question about equitable tolling. If there is a circumstance where there's a change in the law and nobody had noticed that they were supposed to do this, is there a case to be made for some kind of equitable tolling?
This court has determined that before. And this court has previously determined that equitable principles do not override the statute. I have talked about how it is clear and been determined by this court that judgment is a judgment which includes judgments in divorce actions. This statute has its history back into the 1880s. And there have been a number of decisions since then regarding all sorts of different things. And that's why now the statute has glommed onto it by the legislature, the different provisions. But it has long been clear that the dormancy statute applies to domestic relations judgments. Rennie versus Rennie in 1970 was a child support case. And this Supreme Court applied the dormancy statute to child support. The legislature changed the statute as a result of this court's decision. With regard to Laramore, actually, I had a case before Laramore that also dealt with dormancy. That was the Merritt Moore case, which wasn't published. It's unpublished, but it was about a year before Laramore. Decided the same thing as Laramore. So, and clear. And what the Moore case said is dormancy applies to divorce judgments across the board, retirement, everything. But my client agreed with her ex-husband that a domestic relations order would be entered that preserved her rights. And the Court of Appeals said, because there was an agreement that falls outside of dormancy and that's protected. But if you don't make an agreement that it's extended and protected, or you don't file what's required under the statute, refresh the judgment, it's dead after 7 years. Now, a question that comes is that files you may be referring to on if collection is prohibited. But a question comes is after a domestic relations order is approved, whether you still have to file the refreshing of the judgments. That's a legitimate question because legislature and this 2403 doesn't address that. I think best practice is refresh the judgment every 5 or 7 years in order to protect the judgments.
Are you doing that?
I am doing that. I am doing that, and that is included
In
in
terms
my-
of quadros and retirements, anybody that has a capers, what this is, any kind of retirement account, you're after 5 years, you're filing.
kind of domestic relations, divorce decree that includes any kind of judgment, whether it is money judgment or not, because a judgment is a judgment. The statute doesn't say money judgment.
But you're doing it with retirement accounts also.
Absolutely. And that's in my final letter, that the dormancy statute applies to divorce judgments. Or to renew the judgment or contact us to renew the judgment in this time, or else you lose your right. Questions?
Thank you. Thank you to both counsel for your argument in this matter today. We will take this appeal under advisement.